Okay, thank you. We'll make a start. Good morning, ladies and gentlemen. My name is Andrew Tobin. I'm a partner in Mills & Reeves insurance team based in our London office. For those of you who know me, I promise to have a haircut very soon. Stephen King, who was originally going to do this presentation, unfortunately can't be with us today. This is a one-way presentation. You can see me, but we can't see you. If you have questions, please put them in the question and answer box. My colleague Harriet Strevens will collate them at the end. If there are any that I can't answer on the spot, or if we run out of time, we will follow up directly with you later. Also, if you or your teams would like an in-house version of this presentation, or of any of our other cover talks, please just let us know. In the next 15 minutes, I will be discussing insurers' duties to indemnify and insurers' duties to defend their insureds in the context of liability policies. As I'm sure you know, liability policies are insurance policies that are designed to protect an insured against legal liability that the insured might incur to other parties, or sometimes called third parties. Liability insurances come in many varieties, but common examples would be in respect of motor liability, professional indemnity, public liability, employer's liability, product liability, directors and officers liability, and so on. All liability insurances, subject to their terms and conditions, will include an obligation on the insurers to indemnify an insured where it has incurred civil liability to a third party. But not all liability insurances will necessarily include a duty or a right on the insurer to pay for or to conduct the insured's defence of the action. So the duty to indemnify one's insured on the one hand, and the duty to defend it are distinct concepts and heads of cover to which distinct considerations apply. And for that reason, I will consider each of them separately. So, considering first the insurer's duty to indemnify. The central duty on insurers, which is usually set out in the insuring clauses in a policy, is to indemnify the insured where it has incurred a legal liability to another party, assuming that liability is of a type that is covered by the policy. So, for example, looking at the slide, typical insuring clause in a professional indemnity policy might provide for an indemnity in respect of claims first made against the insured during the period of insurance in respect of civil liability incurred in connection with the conduct of the insured's professional business. The reference to civil liability being incurred is consistent with case law that has clarified that an insured's right to be indemnified by its insurer under a liability policy does not arise until the insured has actually suffered a loss. So what is a loss in this context? Under the old cases, the insured would have had to prove that it actually paid money out to the third party claimant before being able to claim indemnity from its insurer. That rule has been relaxed a little, and the current position is that the insured's right to be indemnified under a liability policy arises only once the insured's liability to a third party is ascertained by agreement, award, or judgment, but not upon the mere occurrence of the event which gave rise to the liability. So that also means that the insurer's duty to indemnify only arises in respect of actually established liability and not to mere allegations. And looking again at the slide, as the court said in the AstraZeneca case, in my judgment, what the English cases establish consistently is that the insured under a liability policy will need to establish actual legal liability to a third-party claimant before it can recover from the insurer, unless the particular language in the policy clearly provides to the contrary. That principle has a number of important consequences, one of which is relevant to time limitation, because time will start to run against the insured from the date of its negligence to the third party, but time will only start to run against an insurer for the purposes of the insurance claim from the date the insured's liability was established by award, settlement, or judgment. So to illustrate this, I thought we might have a poll. Leanne, can we have the next slide, please? I think Leanne will bring up a poll. So looking at the slide, let's consider the context of a public liability policy. If a member of the public, let's call him Bob, was injured in 2015, his solicitors at the insured's premises, his solicitors alleged liability against the insured in 2016. They then started a claim for personal injury against the insured in 2017. And by that I meant legal proceedings. And judgment was given against the insured in 2019. The question is, from which point in the chain could the insured claim from its insurer for the indemnity? And so please do go ahead and vote which year you think is the relevant one. Okay, Leanne, are you able to share the results now? Okay, there's a fair division. The biggest group of you, 44%, have correctly identified June 2019 as being the date, but a good number of you have chosen other dates. I think it's important to consider here what we are considering is it is the time limit in respect of the duty to indemnify, not when insurers might need to get involved in connection with a duty to defend. So the answer in this situation is that the insured liability was only ascertained upon judgment in June 2019, and so it would be unable to sue its insurer if it needed to until after June 2019. So although the accident was in 2015, the insured would have had 6 years from the date of its own inwards liability, to the claimant was established to sue its insurer. And that would be 6 years from June 2019 and not 6 years from 2015. So being sued to judgment is one way in which an insured's liability can be ascertained. In the normal course of events, where an insured defends a claim to judgment, that judgment will be very, very strong evidence of its actual liability. Although there are some circumstances where insurers will wish to challenge even a judgment if, for example, there is evidence that the insured didn't defend the case properly or at all, or colluded with the claimant to engineer the judgment. Where an insured has settled its claim with a third party, in order to claim for it from its insurers, it will need to show that the settlement was reasonable with regard to the legal merits of the claim. Settling a claim by reason of commercial pressure rather than on account of legal liability will not normally be covered. For that reason, if an insured wishes to be confident of recovering from its insurers for a settled claim, it would be wise to get insurers consent to the settlement beforehand. In fact, many policies expressly state that settled claims simply won't be covered at all unless insurers' express agreement is obtained. So what we've been talking about so far is the insurer's duty to indemnify the insured in respect of its actual liability to the third-party claimant. But many insureds want much greater protection than that. They want the insurer to pay, they may want the insurer to pay for legal costs incurred in defending its claim. What is the position there? Well, under English law, unless the policy expressly says so, there is no automatic duty on an insurer to defend its insured. That means that the initial presumption at common law is that an insured will defend itself. If that defense fails and it becomes liable, then the duty to indemnify will be triggered. That can lead to strange outcomes. So, for example, where an insured pays for its own defense costs and successfully defeats a third-party claim, and therefore has no liability for the insurer to indemnify against, under English law, it has no automatic right to be able to ask its insurer to pay for the defense costs, unless there is a policy clause somehow allowing it to. And in this regard, the position in England is different to that in North America, where insurers are often expected to defend their insureds under liability policies. In practice, many or maybe most policies contain express obligations on insurers to pay for the insured's defense. And the typical example is on slide 4. In respect of a claim for damages to which the indemnity expressed in this policy applies, the company will also indemnify the insured against all costs and expenses of litigation recovered by any claimant from the insured, and all costs and expenses of litigation incurred with the written consent of the company. So that clause, for example, covers a third party's costs in respect of a successful claim and the insured's own costs if incurred with written consent. But it probably would not cover the insured's own costs of meeting an unsuccessful claim, since such a claim would not be a claim, quote, would not be a, quote, a claim to which the indemnity expressed in this policy applies, end quote. Anyway, the point is that because the cover for defense costs derives exclusively from the policy wording, rather than a rule of law, it's always necessary to check the wording carefully because they can vary a great deal. Importantly, however, insurers that defend an insured should be aware that in some exceptional circumstances, they may be liable to pay claimant's costs irrespective of the policy wording or policy limit because of a power granted to the courts under Section 51 of the Senior Court Act, which gives the court wide discretion to order who should pay legal costs. And this power has been used to award claimants costs directly against insurers where the following 5 criteria have been met. Firstly, that the insurers determined that the claim would be defended. Secondly, that the insurers funded the defense. Thirdly, the insurers had conduct or control of the litigation. Fourthly, that they fought the claim exclusively to defend their own interests. And fifthly, that the defense failed in its entirety. Many policies will give the insurer the right, but not the obligation to take over the defense of a claim. They are sometimes called conduct and control clauses. So, for example, a clause may say that the insurer shall be entitled to take over and conduct the defense or settlement of any claim, or to prosecute in the name of the insured, and shall have full discretion in the conduct of any proceedings and in the settlement of any claim. That's a summary of the clause in the Europools case. The extent to which insurers wish to exercise conduct and control may vary depending on the class of business. In motor insurance, insurers tend to want to control everything, but in professional indemnity insurance, they may be more inclined to take a backseat role, only stepping in if something's going wrong. But whatever the wording says about the extent of control insurers may exercise, insurers still need to be mindful of their implied obligations to their insureds. And may we have the next slide, please, Leanne, which I think is the final slide. So this was made clear in the 1939 case of Groom and Cocker, which concerned a motor insurance claim brought by an injured passenger against two defendants, the claimant's brother, Mr. Crocker, who was driving, and the truck driver who hit them. Notwithstanding evidence that Mr. Crocker was completely innocent and that the truck driver was at fault, the two insurers colluded to admit negligence on behalf of the innocent brother in the hope that the jury would award less damages between the brothers than against the truck driver. Anyway, Miss Crocker or her lawyers must have found out, and the court found that the solicitors who put this scheme into action had been negligent in their duty to Mr. Crocker, and that the insurer had breached its duties to its insured when negotiating with the insured, because it was looking solely after its own interests and in fact prejudicing the interests of its insured. The reasoning in Groom and Crocker has been held in Gan and Taiping to apply to the analogous situation of a facultative reinsurance, where a reinsurer is controlling the reinsured's defence of the claim. The principle being that the reinsurer should exercise its right of control in good faith and in the interests of both parties. A recent and final example of this was a case of Ramsuk and Crossley, a 2018 Privy Council appeal from Trinidad. In that motor case, the insurer admitted Mrs. Crossley's liability without ever having spoken or even corresponded to her about the claim. And in fact, judgment was entered against her way in excess of the policy limits. She had to take that case all the way to the Privy Council in London, which ordered that the judgment against her be set aside. Anyway, the lessons are obvious. So if you're an insurer defending an insured, you must have the insured's interests very firmly in the front of your mind when defending the action. Just 3 points to conclude. In English law, the duty to indemnify is not triggered until the insured's liability is ascertained by award, judgment, or a reasonable settlement. Secondly, the duty to pay defence costs and or the duty to defend do not arise automatically in England. It depends on the policy wording. That's rather different to the position in North America. And thirdly, where insurers do wish to take control of the insured's defence, they must act in good faith to protect the common interests of the insurers and the insured. And I think that concludes the main part of my presentation today. But we do have time for 1 or 2 questions, which hopefully my colleague Harriet has collated.
Thank you very much, Andrew. We do have 1 or 2. The first one is, if insurers have agreed to allow the insured to defend itself, what happens if the insured settles or concedes a claim without insurer's consent?
Well, in practice, nearly all liability policies will contain exclusions or conditions that mean that insurers will not be liable for settlements that have been entered into without their consent. So there would be a contractual reason, a contractual defence that insurers may have to settlements that have been entered into without their consent. Leaving that aside, if the policy contains no such clause, then the insureds will need to be able to demonstrate to their insurers that the settlement they have entered into was a reasonable one, having regard to the legal merits of the case. not there.
And presumably the prejudice to insurers, I guess.
Yes.
Thank you. In terms of the operation of a liability policy, could you just say a little bit more about the differences in the approach between the English courts and the States?
Yes, I'm not a US lawyer, but in the context of the London market, we do sometimes deal with English law policies where liabilities arise in the US, and it sometimes causes confusion because the approaches are different. In the US, my understanding is that generally, irrespective of what the policy wording says, there is an implied duty on a liability insurer to defend its insured, whereas the position under English law is completely different. And I've certainly come across cases where this has led to misunderstandings, either because the claims handler in London either assumes that English law is the same as US law, or vice versa. In fact, they have the approaches are quite different under each system of law. So it's always worth taking advice from lawyers in the relevant jurisdiction to understand exactly what the duties are.
Thank you. Thank you very much indeed. I think that concludes our time for any questions. So I'll pass back to you to conclude this session.
Well, thank you very much for your attention, ladies and gentlemen, and have a happy Christmas. All I need to say now is to remind you that next week, on the 17th of December, my colleague Neil Howes will be considering the topic of directors and officers insurers, and details on how to sign up for that will no doubt be circulated shortly. Thank you very much.